This is the state's motion to revoke bond.
Good morning, Your Honor. My name is Jesse Dreitzer. I represent Mr. Hutto, along with my co-counsel, Mr. Morrell, and Ms. Day. And Mr. Hutto is present in the city back in the courtroom. If you'd like him to stay there, that's fine, or wherever you'd like him to sit.
He's fine where, unless he's testifying, he's fine where he is.
Yes, ma'am.
So, Your Honor, the state filed a motion to revoke bond. I'm mostly relying on my motion for purposes of this hearing. I do want to put the two injunctions that I attached to my motion in evidence. I have certified copies of those. So the final injunction for protection against stalking is a certified document from Suwannee County, would be State Exhibit 1. This would be for Lisa Powers, as referenced in the state's motion. And the final judgment of injunction for protection against stalking against Autumn Howell. This would be State's Exhibit 2 with a certified judgment or a certified document out of Suwannee County as well. So I'd like to put those in evidence, move those into evidence at this time.
Any objection?
No, ma'am.
So entered.
And the other piece of evidence I have is actually something I'm asking the court to take judicial notice of. It is the transcript of the October 17th, 2022 hearing in Suwannee County that resulted in these final injunctions for protection against stalking. State is relying on Florida statute section 90.202 matters that may be judicially noticed, subsection 6, records of any court of this state or any court of record of the United States. So these are, it's a transcript of a hearing from Suwannee County. Its state's position can be judicially noticed by this court.
Any objection?
Yes, ma'am. I do
What's the
believe,
legal basis?
one, under the May provision, I don't believe records would be included as transcripts for the court to take judicial notice of, and as well as its hearsay. Now, I do recognize that hearsay documents can be reviewed in pretrial detention cases and hearings. However, under pretrial detention statute 3.132, the rule specifically says a final order of pretrial detention shall not be based exclusively on hearsay evidence. So although the court will make a ruling on whether it's able to be judicially noticed, it is hearsay. And if that's all the state has, we would argue that would be insufficient in order for you to find that he should be detained pre-trial.
Response?
Can I see what you're relying?
Yes, ma'am.
This is something different, Judge. That's a motion for pretrial detention under a specific rule where the state is asking the court. This is simply a motion to revoke bond. This is not a motion for pretrial detention. That's something different.
So you're saying the rule that counsel Mr. Dreischer's relied on is inapplicable?
Yes.
Any further argument?
No.
The court will take judicial notice of the transcript of the hearing under 90.202 subsection 6.
And I do have those for
Yes.
primary approach.
Dreischer, you have a copy of these?
Yes, ma'am.
So at this time, Judge, the state is just mostly relying on what we put in our motion for revocation of bonds.
I do have a question.
Yes.
As to paragraph 4, you said for final injunctions, it's competent substantial evidence. I thought it was clear and convincing for the entry of a final injunction.
I was relying on the Burns v. Rockerick State with case 2020 Southern 3rd 438, which is I cited in paragraph 3, fourth DCA case of out of which is 2017. The specifically to grant a final injunction, it's the competent substantial evidence. So that's not what the court has to rely on for purposes of motion for revoke bond.
Okay.
It's
It's what the prior court relied on to grant the injunction.
correct.
Okay.
So that's
So for the initial injunction, for the final injunction, the standard of evidence is the same?
the standard of evidence is different. So when you look at a petition, the judge determines if it's facially sufficient in order to grant the temporary. Now, that is, I believe it was in the defense's response that they talked about kind of the extension.
I didn't see defense's response. Mr. Drescher, did you file a response?
Yes, ma'am, we did. We filed.
May I have it, please?
I have a copy of it.
Thank you. Ms. Walensky, you were saying?
Yes, that the temporary injunction was granted because it was deemed facially sufficient, but that is only that only stays in place until there can be a hearing. So, and then the judge has to make a determination based on testimony, which is what we presented to your honor. So it's not necessarily just the allegations that are included in the petition. In fact, the petition itself is not evidence. The petitioner has to present evidence in order to get a final injunction for protection against anything domestic violence stalking. So it's at this time that the state's moving to revoke the defendant's bond because a judge determined that there were at least 2 instances of stalking committed against each one of these individuals. Enough so that he entered a final injunction of protection against stalking until further order of the court, so permanent injunctions. One of the main bases for pretrial release and one of the things that is taken into account by the court, the main would be protection of the community. At this point, a court having determined that the defendant on at least 2 occasions for 2 separate individuals committed acts of stalking rises to the level of alerting this court that the protection of the community is at risk here. And so it's the state's position, absent the records. I wanted to provide the records to the court just in case the court wanted to review them, but on its face, just the documents themselves.
Just the fact that there was an injunction entered against the defendant as a result of these 2.
After a hearing, yes, that should be enough to revoke the defendant's bond if the court needs time to read those. I did want to provide them prior to this hearing, but there was an objection from the defense.
Counsel?
Good morning again, Your Honor. I think a little context may be helpful for the court. In March of 2021, these temporary injunctions were issued against Mr. Hutto having any contact with Ms. Powers or Ms. Howell. By agreement of the parties, we extended the temporaries over and over again. Every 6 months, they would just stay in place. The petitioner's counsel was fine with that. We were fine with that. There was never a request for a hearing. This particular judge that handled the injunction was retiring at the end of this year, and he said, I'm not going to leave this with the new judge, so we're going to have a hearing. It's not as though something had changed. Mr. Hutto had violated the injunction. There was a new law violation. It was just simply the court saying, we're going to resolve this one way or the other. Mr. Hutto did not participate in this hearing. He didn't testify. He called no witnesses.
Was it out of his own volition though?
Yes, ma'am. I'm trying to indicate to the court just the context of how our argument is that nothing has really changed from the time that these petitioners filed this temporary injunction. It was going along and along with no issues until the court said, we're going to have this hearing. We didn't believe it was in Mr. Hutto's best interest to testify. Again, I agree that that was his choice. When Mr. Hutto, when the witnesses testified, this is Lake City. This is a small community in Florida. These witnesses testified that Mr. Hutto drove by the gym. They testified that they saw him at a car wash and that he smiled at Ms. Powers in particular, and that because of those unwanted contacts. And I disagree. The state says that the judge found competent substantial evidence that he committed stalking, as if that was a new law violation. In order to get an injunction of protection against stalking, all the court has to find is that there was 2 unwanted communications which resulted in emotional distress, not that he in fact committed, or there was probable cause that he committed a new law violation of stalking. So that's not what the law said.
Did the acts that generated the temporary and subsequent permanent injunction occur after Mr. Hutto's arrest in this case?
Yes.
Yes, they were after he was released on bond.
In this case?
In this case. So he makes no contact. They never speak. At one point at a convenience store with Ms. Howell, the most communication Mr. Hutto had ever had was he looks at the person who's in line and says, do we know each other? And she leaves the store. Never found to be near their home, never followed in their vehicle, never any act that when the court reads the transcripts would rise to any level of violence or harm to the community. I cannot find, and the state does not provide it, and I cannot provide the court a single case that says that by a civil injunction being entered, that violates a condition of pretrial release, or would be grounds for revoke someone's bond.
But the civil injunction is based on a criminal statute, is it not?
No, ma'am, it's based off of a civil statute that says.
790,
Yes, ma'am, it's
775, wait, I'm sorry, 775 is the statute upon which he's here for today. Right?
he's here because the court found.
The first degree felony is the crime for which he's here for today.
Yes.
Yes,
Okay. Go ahead.
which again is nothing to do with the injunctions whatsoever. They're totally separate and wholly matters. And because there is no case that says that it happens every single day and all over Florida when a defendant has an injunction and they cannot testify in their own defense. Judges grant injunctions and final orders get issued. And there is no case law that suggests that would be grounds. And in fact, we cited in our response that unfortunately you haven't had a chance to read, but you'll see is that in the closest case that we can find, which is Leah for the Jen, JENNE 708 Southern 2nd 980. That's a case where the victim was actually the victim in the criminal case. And that person actually violated the injunction, which is a criminal violation. And the court, the appellate court found that would not give rise to violating an injunction because, or the pretrial detention in the criminal case, because in fact, a few phone calls to the victim would not rise to the level of danger to the community. We've outlined that case and its holdings and its findings in our response. So the closest that we could find is where someone actually, remember, I would point to the court that when there is a civil injunction and then you violate that injunction, that is a first degree misdemeanor. Mr. Hutto has not done that. There has been no change with the exception that a injunction was filed and a court then entered the final. In this particular case, that's the only change that has occurred. There's with no allegations other than there was these unwanted contacts in a small town where they didn't speak. He doesn't follow them. He doesn't hit them, shake them, say anything derogatory. And I would also note to the court that is also currently under appeal. We have filed an appeal and it's pending now on the injunctions that were issued.
Does that complete your argument, counsel?
I would just lastly say that if the court finds that in order to find that he would be detained, the court would have to find that there is no other conditions that could keep the community safe. In the state's own motion, they suggest that if the court's not willing to do that, you should put a GPS ankle monitor on them. I would suggest that the state's saying that there is in fact a way in which the court could make the community safe, and they give the court a tool to do that. And we say in our response, we don't think that's necessary, but if the court wants to put a GPS monitor on Mr. Hutto, certainly that would be an alternative non-monetary condition of bond that presumably could keep the community safer in the sense that the court system would know where Mr. Hutto was during his time of pretrial release. But we don't believe that there's any case law support for detaining him. We don't believe that he has posed any danger to the community with the acts that they suggest, and that there is really no change from the initial 2021. And we ask that the court allow Mr. Hutto to remain out on bond pending trial there.
One other question I have for you, Mr. Darsher. Does the court need to actually review the transcripts in order to rule? Or to Ms. Walensky's point, can the court rely on the motions that have been filed in your response in conjunction with the two certified copies of the injunction that has also been admitted?
I don't believe the court needs to read the transcripts. I don't believe the entry of a civil, if you were found to be in bankruptcy and there was a bankruptcy order, which I don't think a civil order, which they have entered in evidence without objection, would be sufficient for the court to deny Mr. Hutto his right to be out on bond. So I don't believe that the transcripts are necessary. In fact, we objected to them, as you know, just moments ago. So I think it would be not so genuine for me to say you have to read them.
Thank you, sir. Does that complete your argument?
Yes, ma'am.
Ms. Walensky, same question. Is there a need for the court to read the transcripts in order to rule, or can the court rely on the pleading that she filed, the response that Mr. Drescher filed in conjunction with the actual injunctions that were entered by the court in Suwannee County?
I think that the court can rely solely on what we put in evidence, which were the two injunctions. The purpose of the transcripts was solely if the court felt like it needed more information as to what led to, especially because the petitions, which were not evidence in the actual hearing and for not evidence relied upon to come to the actual final order, were attached to the defendant's response. I just wanted the court to have the context, if needed, as to why the actual final injunctions were entered. So I think the court can rule based on the civil injunctions. And I would like to answer one question you asked to the defense, if that's okay with the court.
Yes,
Your Honor asked if the civil rule for the injunction is relying on a criminal statute. So it relies, there's a civil statute that talks about when injunctions can be put in place and what's required. And then there's a litany of case law. I cited some as to what's required. However, the definition of stalking is the definition of stalking.
Which is a
comes
crime.
from a criminal statute. So while the judge did not find, the judge doesn't make that determination whether or not there's probable cause, whether there should be an arrest, the actual definition is from a criminal statute. And that's 784.048 Florida statute.
all right, that was my question, and I appreciate you answering that. The second, so that was one of my questions. So I guess my third question, because you answered my second, is he says that you articulate a less restrictive means for ensuring the defendant's appearance by suggesting the use of an ankle monitor. Explain your what is your response to that?
I don't think that that's enough. The state does not believe that's enough. It was only if the court found that this was too restrictive or too much of an ask, really. We think that his bond should be revoked. That was the main portion of our motion. It was just an alternative if the court did not think such a drastic state's position that it's within the rule, and not so drastic, but such a drastic ruling would be appropriate. We gave an alternative because we didn't want to see the motion get denied and we're back to status quo, because status quo is not working.
Another question based on your response about this, the stalking statute, which I appreciate you answering preemptively. The standard that the court relies on when issuing an injunction is competent substantial evidence. If Mr. Hutto had been arrested for stalking, it would be probable cause. So isn't it that the court has based its order on a higher standard than if Mr. Hutto had been arrested by the state attorney in Suwannee County for the stalking, which would have brought us back here anyway, because then you would be here saying that Mr. Hutto had violated a criminal statute in Suwannee County. Hopefully my question is clear.
Yes, it is. Competent substantial evidence is a higher standard than probable cause. So that this court in Suwannee County found 2 instances of stalking by a higher standard than what would be required to revoke his bond on a new arrest.
And question, and Mr. Drescher can respond to it and you get the last word. The court can rely on that as a basis for the violation, even if the state attorney in Suwannee County chose not to arrest Mr. Hutto for the stalking.
Correct.
Anything further from the state?
No, Your Honor.
Mr. Drescher?
And again, having tried a number of these stalking injunctions, that is not the standard. The state is conflating 2 issues. The court is not dissecting the stalking statute.
Let me be clear on my question so you can respond to it, and I'll let you certainly complete your argument. The genesis of the court's question is that Mr. Hutto, by a court of competent jurisdiction in Suwannee County, found by competent substantial evidence that Mr. Hutto committed the acts of stalking. Civilly, I get you, but it's a higher standard than if the Suwannee County state attorney had arrested Mr. Hutto for that same violation, right?
No, Your Honor.
Okay.
Where I disagree with the court's analysis is that is not what the court is finding. Competent substantial evidence that he committed stalking. In every single appellate review of a stalking injunction or protection against violence, they're all different and they have certain elements. The elements of the injunction stalking injunction for protection and stalking is not whether he had competent substantial evidence that he committed two acts of stalking. That's what the state's saying. That's not the elements. The elements are two unwanted contacts that create distress. That's what the court found. Those competent substantial
So the
evidence.
statute is not being used in the analysis when the court issued the injunction?
It's not. It's used to determine the definition of what stalking is for a stalking injunction, but that is not the elements that the court finds substantial competent evidence in order to find a injunction. Every case in Florida would say that in order for the court to find that there's a stalking injunction, determined that there's two contacts and it causes emotional distress. The stalking statute doesn't ever address emotional distress. It was read today. It's in their response. And I would add that under Section Paul, if the court were to determine that that is enough to revoke.
That's the case that you cited earlier.
No, ma'am.
This is a new case.
This is a new case.
It's cited in your materials. I just wanted to make sure.
Yes, ma'am. And I sort of went through, and at the end, I talked about if the court were to find that his bond should be revoked, under State v. Paul, the court then would need to have a bond hearing to determine if there are any conditions of bond that Mr. Hutto could be given in order to satisfy the protection of the community. And only can he be held in pretrial detention if the court finds there are no conditions of bond that would protect the community and secure his appearance.
At a revocation motion, isn't it the burden on the defendant to provide the court with evidence in the alternative to say, if the court is inclined to revoke the bond, judge, I want you to consider an alternative, and these are the issues or facts that I want the court to consider? Or are you saying that I have to bring everybody back here?
No, ma'am. I'm saying, and I put in my response that the procedure would be first you have to revoke, which I don't believe that you should, but if you do that, then the next step is we ask for you to consider.
Which, and that's my question. Maybe it was not clear. Shouldn't that be done today for judicial economy? Or you asking me to bring you all back here after, if the court is inclined to revoke the bond for yet a second hearing?
No, but we're prepared to do that.
Okay.
So I don't. If you rule now, we can come back.
I can't rule now because I haven't read your response.
Okay. Well, we would ask that after you read our response, that if in fact you are inclined to revoke his bond, that there are many conditions of bond that would keep the community safe, such as a GPS ankle monitor to know that he doesn't go anywhere near those particular people that have injunctions.
And you don't want to put forth evidence today.
It's by way of argument. I don't know how we would put on evidence as to typically it's argument in a bond hearing as to what would keep the defendant safe, GPS monitoring. I thought you'd get generally evidence from the defendant of his ability to pay some type of bond and things of that nature. But if you're not going to put forth that evidence, I get it. I'm not forcing you to do it. I'm just asking you if you want to do it. The way I see this case is, I don't believe the state's even making an argument that there is in fact a flight risk. He's appeared at all his court dates. He's here today. This is strictly a protection of the community argument. He's had no violations of this bond. He's had no new law violations. He's had no arrests. But I suppose it may not be in the most judicial economy way. I think in order to do this effectively, I have to know what your ruling is. That we have to file a bond motion. I guess we do that as separate.
Thank you, sir. Does that complete your argument?
Yes, ma'am.
As the movement, you get the last word.
No other response.
I will take this under advisement. I've just been handed by Mr. Drescher his substantive response. It's 11 pages. I want to review that prior to making the ruling. I wish to order. Hopefully, have a trial. I'll try and get it either today or tomorrow.
Thank you.
Thank you. Next case ready to go?
Judge, I can address the case of Rothschild Pierre Luis on page 3 of your honor's docket. This is 22 CF 008475. Mr. Pierre Luis is present in the courtroom. We're here today on a bond motion, your honor. Essentially, it's a motion to release Mr. Pierre Luis to the Millennium Clinic for mental health treatment.
I read the motion, Mr. Gordon. Anything further that's not contained within your motion before I hear it comes further?
Yes, your honor. Just briefly, the reason that we're before the